Thanks, everybody. Derek, thank you for the introduction. Hello and welcome. We are going to talk about Open Meetings Act, interplay with FOIA, some hot topics that have come up with some recent case law as it relates to committees and subcommittees. And I'll try to give you as much as I can in the way of practical pointers other than just the nuts and bolts of these various things. So, Derek, I don't have the chat popping up, so please interrupt me as questions come up. We'll try to get those answered. And I'm going to give you the conclusion before I go through the slides. So I'd like to note some key takeaways at the beginning of this sort of in summary. First thing is if there's no notice, no meeting. So if you've got a public body and you're sitting down and you're talking, please somebody verify that the meeting was actually posted in the right place. That includes physically at the office of the county building so that it can be seen. If you maintain a website, it also needs to be on a website. So if you're scheduling a meeting last minute, make sure you've done it right. Make sure that there's a posting. Number two, the solution for non-conforming decisions, whether that was improperly going into a closed session or holding a meeting that wasn't posted, is reenactment. One example of this is that if you go into a closed session improperly, you can't fix it by releasing the minutes from the closed session. You actually have to reenact that discussion that happened improperly in open session. And then there's no prejudice against you for doing that. So that cannot be used against you if somebody challenges the discussion in the closed session if you reenacted it properly. Reenactment, obviously been around for a long time. I don't see it happen very much, but if you think something's off or you find out that the notice had the wrong date or time, reenact what happened and you fix the problem. Number three, please be careful with your emails and your text messages, especially during an open meeting. You don't want to have communications amongst members of the public body happening outside of the view of the public. And what usually gets uncovered is somebody sees people typing away on their laptop, whether they're in the meeting or whether the meeting's broadcast by Zoom, and asks for information for public records under FOIA for any and all communications by Commissioner X during the date and time of the meeting. If that commissioner happens to be communicating with their spouse about dinner plans, not a public record, no problem. If they're communicating with the county administrator, they're not a member of the body, so they're not going to be Open Meetings Act violation, but it could be a little embarrassing and it could come out because that may be a public record. And if they're communicating with other commissioners, it could be both an OMA violation and something that you didn't want disclosed via FOIA. So just a quick note on that. We'll get into more detail on that. And the last point is really the most interesting area, in my opinion, of what's happening right now, which is the concerns with delegation to either even an individual or another group of people, whether you're calling it a committee, a task force, a work group. There's been a couple of recent cases having to do with marijuana licensing, and the court is really clamping down on something that we've been aware of for many years, which is the importance of having a committee, subcommittee, whatever you call it, if they're delegated a responsibility of the board, that they need to use the Open Meetings Act to conduct their meetings. That is something that a lot of places have been, I guess in my experience, a little lax with. They're calling them purely advisory committees. I will tell you now that the state of the law is such that there isn't much left to an advisory committee. If the committee makes no recommendation, it still could be subject to the Open Meetings Act. If the committee puts forward every recommendation and lists them 1 through 25, all 25 go forward, that may be subject to the Open Meetings Act. That's what that case on the marijuana review said. So the advice that I'm giving clients now is that if you're delegating something that the board was going to do, whoever you're delegating it to should be following the Open Meetings Act. I think the most troubling piece of that, from my perspective, is the case out of the city of Royal Oak. And that case stands for the proposition that when the city commission approved the city manager's rankings awarding marijuana licensing, that the court viewed the city manager as the de facto decision maker in the process, effectively a one-person public body. I have some issues with that from a technical standpoint, but that's what this case says. So what the court found is that the city manager's closed-door meetings with staff, where those rankings were made, constituted a delegation of the decision of the governing body. And so even those internal meetings with the city manager and staff required compliance with the Open Meetings Act. So for instance, if you've got a personnel committee that's supposed to be reviewing things with the bargaining unit, and you delegate that to the county administrator, that delegation may result in the county administrator and whoever they're talking to being a public body under this line of cases. To me, that is a very significant change in the advice that we previously would have provided here, which is that you don't have one person public bodies with professional staff. This is very fact sensitive. I don't want to cause panic, but I think that this is an area of the law that's going to be subject to more and more challenge. The public is certainly aware of this. I noticed that in certain jurisdictions that I attend and go to. But my perspective on this would be that if it's a job of the board and you've delegated it, you should be asking the question, do we need to post this as an open meeting? And that's a pretty big change in the last year over this theory that certain bodies, whether they're purely advisory or not, or individuals, wouldn't be subject to the Open Meetings Act. I'm sure that might generate some questions. I'm not trying to upset the apple cart here. Our advice has always been to err on the side of posting. So even if you have a committee or you call it a work group that doesn't even include board of commissioners on it, if the commissioners have assigned a task that they would review, our advice has always been post that. That should be a special committee or ad hoc and have that posted as an open meeting. Whoever's assigned to it, follow the Open Meetings Act, and then you're safe. I think you want to err on the side of caution, especially with these recent case laws as it relates to delegation of board decision making to another public body. That definition of public body has really gotten strict. So on to the Open Meetings Act, unless that elicited questions already, Derek. Have any come in on that?
I don't see any yet. I see Vaughn with his hand up. Vaughn, can you type your question into the chat, and I will relay into Matt. So,
I'll keep going, Derek.
Yep, keep going, and then I'll circle back to you.
All right, so Open Meetings Act, not a new law. All of you are likely familiar with it. It's going to approach its 50-year anniversary here pretty soon. We do have some pending legislation. At this point, I'll let Derek talk about that a little bit at the end if he has information on it. The legislation that I'm most interested in relates to the ability to hold meetings electronically. There's been some movement that has not gotten past the initial stages of the legislature on freeing up the ability for boards to have people on the board participate electronically. Right now, that's not available unless you're on active military leave or subject to an accommodation under the ADA. So if you're conducting electronic meetings of a public body, you need to make sure that your members meet one of those two criteria if they're going to participate. And participation means taking part of the discussion, voting, deliberating. Basically, if they're doing something other than a member of the public would be able to do, which is basically public comment, they need to make sure that they have the ability to participate under one of those two allowable exemptions under the law.
Right. Matt, real quick, just circling back to the cases you were mentioning regarding delegation, we do have a question about will you be sending that case law? I presume those references will be in the slide deck that we're going to provide.
So Derek, why don't you include that article that we put out in February that talks about delegation to the group. That summarizes all of this with more detail and has citations to those cases.
Will do.
Great. All right, application. So I've just gone on a little rant about the broadening scope of the act and its application. But in a nutshell, it applies to any state or local legislative or governing body, including a board, commission, committee, subcommittee, which is empowered by the state constitution, statute, charter, ordinance, resolution, or rule to exercise, here's the magic word, governmental or proprietary authority to perform a governmental function. So if you've got a body that's handling business for the county, the question should be asked, does the Open Meeting Act apply? And the answer in almost every situation is going to be yes. And so that's the standard in the law. I mentioned that recent case law and what I see as limitations regarding what is actually an advisory committee. I just to reiterate, our advice used to be if the committee was taking everything in and putting everything back out to the board, that was purely advisory. But when they were narrowing things down or eliminating options, it was no longer advisory. I think now with the changes in the case law, it's pretty hard to make an argument that unless they literally take everything that they did and move everything forward without a recommendation and just say, here it is, they're probably not going to meet the standard as purely advisory. So I think that's an important thing to note and some changes in evolution based on the case law. What's a
And
meeting?
oh,
Derek?
got a quick question. Uh, what about bargaining unit meetings?
Oh, such a good question. So I'm very careful to describe, because I do a lot of labor negotiations, what is a bargaining team versus a bargaining committee. And para applies in the case of a bargaining team, which requires the discussions at the table remain confidential. I would not put a quorum of a public body on a bargaining team. I have clients who assign commissioners to the bargaining team where I serve as the chief negotiator. I think you want to be very clear that you are not creating or delegating the decision making at the final step of the process to that committee. Don't call it a committee, it's a bargaining team. And so as long as you don't have a quorum and you're giving that committee the bargaining, I keep using the word committee, the bargaining team direction, and they're coming back with you to ratify, I don't believe that a bargaining team in that situation is subject to the Open Meetings Act. But this case, I will tell you, made us look very carefully at what we were doing with bargaining teams. And so if you've got a situation, maybe a smaller county where you have 5 commissioners and 3 of them are assigned to the bargaining team, that's a quorum of the full board of commissioners and technically should be posted as an open meeting if they're meeting and going back and forth towards the decision on that governmental function, which is approving a collective bargaining agreement. So please be careful with that. It's a fact-sensitive analysis. I have no issue and actually think that it works out really well in a lot of cases to have commissioners on the bargaining team, but don't be a quorum. And for the boards that are assigning people, I would make it very clear who the lead negotiator is, who the staff representatives are to be for the employer. Obviously, elected officials are legally entitled to be on the bargaining team if they have employees in the bargaining unit. And then I would just be careful not to create a quorum of a public body in the creation of your bargaining team. So that's a really excellent question and something that we are being very careful with as we move forward on this. I do think it's a bit of a conflict with para to the extent that bargaining needs to be confidential. But I suppose if you did create a public body through your bargaining team and you posted it as an open meeting, I think you could go into closed session because one of the exemptions for closed session is to discuss collective bargaining. So even if you had that situation where you had a quorum of a board of commissioners on the bargaining team, you could go into closed session. This is pretty cumbersome. This is kind of another step in the process.
Following up on that question, does every public body need a bargaining team?
No, you just need somebody to be the representative for the employer, which for any bargaining units where the county board has employees, either as a co-employer, for example, if you have a sheriff's office union, the board of commissioners is the co-employer in that relationship, handles economics, needs to have somebody with authority to negotiate. That could be the county administrator only, that could be the county attorney only. I have not had much experience as just the only person at the table. Can't think of too many times where I've done that. I serve as the lead negotiator for a number of counties around the state, and the bargaining team generally consists of myself. It might be a county administrator and HR director in some places, and no commissioners, or 1 or 2 commissioners, and then whatever professional staff are there as a resource and to make sure that I don't do anything that the county wouldn't approve at the end of the day.
Another kind of related question, you brought up closed session. What can boards do and not do in closed session when they are reviewing administrator applications?
Okay, great question. And I'm happy to jump around. I have a slide deck that's kind of in sequence, and so I may repeat this, but the closed session exemption for applications allows you to review applications for employment if the applicant requests that they remain confidential. But once you have decided who to interview, That decision needs to be made at an open meeting, and the interviews have to happen at an open meeting. So the only thing that you're doing in closed session is reviewing the applications that you received, and then you're coming out and you're making a motion. You might not interview anybody, so you could make a motion to continue the search, or you make a motion to offer interviews to 1, 2, and 3 applicants, and then those interviews must be done in an open meeting of the Board of Commissioners for those jobs that report directly to the board. And there may only be a couple of those: health officer, county administrator, controller, but other counties have a number of even department heads that report directly to the Board of Commissioners. So you wouldn't have a layer necessarily where there's a review of applications outside of the board's purview, but you could. If you've got a bigger county, and I know you just asked me about administrator, but I'll keep going with this. HR may function as the reviewer of all the applications, and then the administrator, the department head, might be making the hiring decisions. But for the administrator specifically, closed session to review the applications, open session to say who you're going to interview and conduct the interviews. All right. Open Meetings Act, what is a meeting? It's a convening of a public body at which a quorum is present for the purpose of deliberating toward or rendering a decision on public policy. Quorum is not statutorily defined. Board rules can set different quorums, but for the Board of Commissioners, because you have to have a majority of those elected and serving for the final passage of a motion or resolution, you should be operating under the assumption that you need a majority of elected and serving constituting a quorum. Committees, you can set up your own quorum requirements. I've got clients who have 7-member committees with a 3-member quorum. That's obviously less than a majority, but that's not a problem. The law doesn't define what a quorum is, but you do need to be clear on how many votes it takes to pass something. If it's a committee, you might just say a majority of the quorum is necessary to pass. And so it'd be a sliding scale of what's required. But at the board level, again, on the final passage of a motion or resolution, it needs a majority of those elected and serving. And that's generally what we're looking at when we're talking about is a quorum present. So if you've got 7, quorum 4. Open Meetings Act talks about deliberating and decision making. What does that mean? Well, it's the exchange of views. It's not strictly defined, but if you're considering issues, bouncing ideas back and forth, discussing what to do, the act might apply. The word decision, making a final determination, an action, a vote, or a disposition on a motion, that needs to happen in an open meeting. There is the ability under the Open Meetings Act for one-on-one communication. There's AG opinions on this, taking a straw poll. That's different, a little different in my mind, than deliberating and making a decision. So if the board chair calls up and says to each commissioner one-on-one, hey, how would you vote on this if this issue came up? And it doesn't turn into a debate, there isn't lobbying back and forth, that probably is fine under the Open Meetings Act. And the way I say probably is because it's really a slippery slope when you start saying, well, here's what I think, and here's what I think, and here's why I think that, and then you start relaying what other people thought. All of a sudden, you could have this sub-quorum issue pop up. So I don't want to tell you can't talk about issues. I think one-on-one, definitely. The problem is when you start linking people, whether it's ideas, discussions, deliberations. I see this a lot in emails. And this is the email FOIA interplay here, which is that if a county administrator sends out an email with an update, I would either blind copy everybody if you're sending it to the Board of Commissioners, or indicate right in the email, please do not reply all. The first response from a commissioner with a question back to the administrator is likely fine. The second response, weighing in on the first commissioner's response, all of a sudden you probably are documenting deliberations toward a decision on a matter that's coming before the board. And from a FOIA standpoint, that's likely going to be a public record. And whether or not an exemption applies, you should assume, whether it's a personal email account, a government email account, if it has to do with something in your performance of your duty for the public body, it's potentially a public record subject to FOIA. Exemptions to FOIA are discretionary. Exemptions can be claimed, but I wouldn't just blanket assume that whatever we're doing is exempt. I would assume that if you're corresponding in an email or text on behalf of the public body, that could be disclosed under a FOIA. Even if it is exempt, FOIA requests can be appealed. So if somebody submits a FOIA, your FOIA coordinator says, no, this falls under the exemption of preliminary deliberations or notes of a public body prior to a final decision, which we might attach to an email. The person appeals, makes a compelling case to the Board of Commissioners, or if you've got a committee who's been delegated the responsibility to hear appeals, the board can reverse the decision of the FOIA coordinator. And boards do that because sometimes they feel like, well, this is better than getting sued and finding out we're wrong. People don't have to go to the Board of Commissioners for an appeal. They can skip that step and go straight to circuit court and challenge the FOIA denial if you claim an exemption. But more and more people are taking that step and making an appeal to the head of the public body, which is the Board of Commissioners, and then it's up to the board. And so if you were that commissioner on that embarrassing text string or email or just said things that you didn't want the public to know about, it could all get disclosed. And so that's just an important thing to understand on the way that FOIA works. I'm a big advocate for utilizing exemptions because I think they're important, but at the same time, it's the board's call. And by the board's call, I mean the majority of elected and serving commissioners on what to do on a FOIA appeal if it goes to you. And I think that's just something important to note. Voicemails are FOIAble if they meet the public record requirement. Text messages, where they are, whether it's on a personal phone or not, isn't dispositive of whether or not it's a public record. If you get a FOIA request for any and all electronic communications, we rely on you. So if you say I don't have any on my personal cell phone, fine, we're going to not produce anything. But if an individual challenges that and goes to circuit court, you might be facing a subpoena for your records from Verizon. So be careful. Be careful with the electronic communications. I think that the modern world has created a lot of opportunities for problems with public records, just the way that we communicate now. I encourage people to pick up the phone or talk to each other in person. I think that's a good way around creating a public record. I'm not telling you to avoid FOIA, but I think there's just some things that are better left unsaid in emails, and picking up the phone and talking to somebody, especially one-on-one, might be a good way to resolve an issue instead of blasting everybody through a reply all email chain. And I think those are just important things to consider in the way that you conduct business, whether or not you're county administrator or county staff or one of the commissioners, an elected official.
Okay. No questions right now. I'll toss a question out in the scenario you just discussed. Let's say there's a FOIA request, FOIA coordinator denies it. Requester goes to the board. The board reviews it, majority votes to uphold the denial. If let's say a commissioner is outvoted, but possesses the information on their personal device, what happens if that commissioner provides it to the requester anyway?
Well, it's pro form. It depends what it is. If it's let's take attorney-client privilege. That's a pretty common one that we see. An individual commissioner cannot waive attorney-client privilege for the Board of Commissioners officially. Functionally, they can. So we operate on the honor system in that regard. And if you receive an attorney-client privilege communication and it's FOIA'd, we would ask you individually not to release that unless the full Board of Commissioners agrees to waive privilege. As your attorney, I don't hold the privilege. I can say to you, I have no issue with releasing it, but it's your call. And by you, I mean the majority of elected and serving. But Derek, to your point, when and if that happens, it's out there. And other than censuring the member and telling them, don't do that again, not a lot that a Board of Commissioners could do about it. We try to operate above board, but I'm not saying that somebody doing that is not, but we would ask that it be a little more coordinated if that kind of thing comes up, just to make sure that you don't have an inadvertent waiver of privilege.
Right. I think that would be more likely. A more likely scenario is somebody gets confused and shares something that, like, oh, wait a second, and it's too late.
And you've got, I'm sure, especially commissioners on this call, have constituents contacting them for information all the time. And they may ask, what are your thoughts on this? And you may forward an email string, and the email string contains your thoughts. From an Open Meetings Act and a FOIA standpoint, that may not be an issue at all. But if the email string is 4 or 5 commissioners debating the use of a county facility, all of a sudden we may have just uncovered an Open Meetings Act problem. And if we get it early, okay, let's just reenact that. We'll have that discussion that happened in the email at a board meeting, no harm, no foul. But otherwise, you might be subject to a claim from the constituent you're trying to help out saying, hey, you guys are deliberating toward a decision in an email string here. That needs to happen in an open meeting. So these are the ways that these things come up. It's not the end of the world. We certainly see it quite a bit. Reenactment is the cure. Meeting informally. So the old days of having the pre-meeting at the local diner before the real board meeting hopefully are over. That does not fly. Even if you're claiming that we are reenacting, don't set yourself up for that, because reenactment still can cause some problems, because you need to demonstrate that everything that you talked about at the meeting that wasn't open happened at the meeting that was open. So there's no exception for meeting informally if it's a quorum of the Board of Commissioners to go over things that are about to come before the board at a public meeting. So those discussions, the whole point of the Open Meetings Act is that people get to see the sausage getting made on those decisions. You can certainly have a consent agenda. You can certainly have decisions that aren't controversial where there's no discussion. But what I've seen in my past experience is that when there's a highly controversial decision, and there's a motion and a second and no discussion, all those in favor say aye, and it's unanimous, people start to get a little suspicious. That looks like the rails were greased. They may not have been, but that's where things come up. So I would encourage people not to make meetings longer, but use your discretion. If you feel like you need to provide input on why you're making a decision, please do. That is the entire point of the Open Meetings Act, is so that the public not only knows what the decisions are, but understands why they were made. There's a few exclusions to the Open Meetings Act. What we're doing today, if there were a bunch of you from one county constituting a quorum and you're attending this as a training or seminar, it's not subject to the Open Meetings Act. You want to be careful though, if you're at, let's say you're at one of these great MAC conferences and you all get together and you're talking about what to do with your health officer, not to pick on health officers, and there's a quorum of the board there, you need to be careful. That could fall under the informal meeting instead of an exclusion for a training. You got to pay attention to the topic. And the act also doesn't apply to social gatherings or things like that. Just like anything though, I mean, we have to be real. We talk about work. All of us do it, especially when you're with colleagues. So it's just something to be aware of. I don't want people to be overly sticklers to everybody who's sitting around talking if you're members of a board of commissioners. But if somebody gets into it on an issue that is going to come before the board, whether it's in an email or in person, I would urge somebody to say, hey, maybe this is something we should talk about at the meeting. I think there's a nice way to do that. You don't have to be nice, but I think that it's one of these things where you want to look out for each other. And it's not just if it's overheard or if it's in private, it's really, are you doing what you're supposed to be doing as a member of a public body with the Open Meetings Act? Open Meetings Act covers public comment. Rights of the public are very important. That's a key reason that we have the Open Meetings Act. Want to make sure that you have at least one opportunity in every board meeting for public comment. That's legally required. I urge people, if you're only going to have it once, to have it before decisions are made at the meeting. There's no agenda requirement in the Open Meetings Act, but most public bodies post an agenda. And so in the agenda, there's usually a format that's followed. Public comment, if there's only one, should happen before you take action on things. I think that way you don't have people coming to your meeting, listening to all the decisions that were made, and then waiting till the end to tell you what they thought about it. I would say that the vast majority of boards that I attend have 2 opportunities for public comment. One at the beginning, one at the end. Boards can put rules. You can say that first public comment is things that are relevant to the items on the agenda. Second public comment might be shorter. it just needs to be uniformly applied, and I really discourage you from having what I call content-based regulations. So the First Amendment, the right to petition the government, is fundamental. If you're only going to have one public comment, the only rules I'd have on it are that there's some amount of time limitation and you can't breach the peace or threaten people. If people want to come in and talk about the moon phases, let them do it if you're just going to have one public comment. If you've got two, have one be general. Same theory. Making sure that people get to come in and say what they want to say to you is really important. If you've got a meeting where you've got 150 people and they all get 3 minutes and your meeting's going to take 6 hours, the way to get out of that is to recess and reconvene the meeting. You don't need to be held hostage overnight for a controversial issue. You do need to let the process play out. You can't just say, oh, we're going to close public comment for tonight's meeting. The rules need to be uniformly applied. Whether or not you have people give their name and address, that's up to you. You don't have to. If somebody comes in and says, I want to be anonymous, I'd let them comment. I don't think that you need to be a stickler on the rules, even if your rules allow for people that have to say their name. There
Right.
is no registration requirement to attend a meeting. So those two things are an important distinction. I'll stop. Take a breath, Derek. I see a bunch of
Right.
questions popping up.
Yeah. Yeah, Matt, circling back on that, what, if any, information can an individual be required to provide the board in order to provide public comment? I think you touched on that, but could you cover
So
that again?
the board can put reasonable rules in place for public comment. And a lot of boards have, name, residential address, things like that. So you can, that's defensible. And there's case law that says you can have reasonable rules regarding public comment. What I would not do, and I don't think would be enforceable, is say we're not going to let anybody who doesn't live within the county make public comment. You can still have an address requirement. If somebody says, I don't want to say where I live, um, barring them from public comment, I suppose you could, but why invite the scrutiny? I think having the rules, being a little flexible on them, people get nervous. People want to remain anonymous. You can have a rule that says they must identify themselves by name. But if somebody comes up and says, my name is Jane Doe and I live at 555 North Main Street, let them comment. I mean, maybe that's their name and address. I don't know. Or they just want to be anonymous. I just don't get too hung up on that. What I get more hung up on is personal attacks, people going after an individual. I'm a big proponent of part of your rules, part of what you say to people is direct public comments to the chair. And this is your opportunity to comment. It's not where the board engages in back and forth and debate. If somebody wants information, somebody can follow up with them after the meeting. I do not like a two-way street on public comment, especially on hot topics, because it tends to devolve and then we've got a problem. If somebody is attacking an individual commissioner, I urge chairs to use the gavel or however you interrupt a meeting and direct that individual back to you. That usually sort of sets a little light off for somebody. Like, okay, we're in a professional setting here. It doesn't always work. You may have to rule them out of order if they continue with their personal attack or if they make any threats. I've sat through hundreds of board meetings. I think I've only been at one or two where we had to remove somebody. Most of the time, if things get heated, interrupting somebody and reorienting them to the purpose of what they're there to do usually is effective.
All right.
Um,
Next question related, and just reiterate again. Question is, can one of the public comments be dedicated to only agenda items? You touched on that, but
yeah. Yep. But I would, in that situation, have a second one at the end that's maybe shorter, but on any topic.
right. And then another question here, going back into committees. Uh, with a county with a board of 5 members, can a commissioner attend a subcommittee that has 2 commissioners on the subcommittee? The commissioner is there as the public and does not participate in the discussion or says anything, but just attends to hear what is happening. So I think that goes into the participation realm.
I think that's a question about whether or not it's a meeting of the full Board of Commissioners. And under that scenario, that's fine. But if you have people that are, let's say, like I have some counties where the chair is a member of every committee and may be there. And if that scenario happens where it then becomes a quorum of the full board of commissioners, the way to fix that is to post committee meetings to say, and a quorum of the full board may be in attendance. And then you've got it covered. I think what the issue the person asking that question is identifying is whether or not it needs to be posted as an open meeting of the full board of commissioners. And if that happens, if people come and they're allowed to comment or participate, do it as both. Have it both as a committee and there may be a quorum of a full board of commissioners in attendance. That's a great
Okay.
question.
Next question. If HR or the administrator issues performance reviews, should the reviews be presented to the board to review before issuing to the employee? And then related, would these be considered for open meeting or closed session?
Well, performance reviews can occur in closed session. Typically, further down the org chart, I don't see clients dealing with performance reviews at the board level unless it's the county administrator or direct report. An important thing to note on that closed session exemption, you can only go into closed session if the person being reviewed asks to have it done in closed session. So step one, if you're going to do a performance review, the person being reviewed needs to request, if it's going to the board, that it happen in closed session. They can be invited into the review. Most cases are. If they're asked to leave the review and the closed session is ongoing, just note that if they rescind their authorization for the closed session, it's over. You're coming back out and having the discussion in open session. So that is one where you need to make sure you've documented that the person being reviewed is asking for the closed session. The board doesn't have to go into closed session, but a threshold issue to get you there is that the individual being reviewed has to ask. And if they ask, it's still a vote of the board. The board could say no, and then that review is happening in open session. So that's an interesting one. It's kind of a complex back and forth depending on the fact pattern. 9 times out of 10, it's perfectly smooth. People are used to it. It happens in closed session. They come out. Whatever motion is made is made. One related thing to that, if you've got somebody like an administrator, don't negotiate their contract in the closed session. You're reviewing their performance in the closed session. And if you're going to make changes to the contract because they had a good performance review, that either needs to happen in open session or a different basis under the Open Meetings Act. For instance, attorney-client privilege communication, if there's something that the attorney needs to weigh in on. Like let's say the administrator wants to double their severance, we can provide a review and analysis of that, and then you can talk about that under a different basis of closed session. But don't conflate or combine topics. That goes for every single reason in a closed session, because you have to be very specific in scope in order to maintain the ability to keep it in closed session.
Okay, we're caught up on questions.
All right. Moving on, the right for a person to attend a public body, a meeting of a public body, includes the right to tape record, videotape, broadcast it live on radio or television. I see Facebook Live quite a bit, as long as they aren't disrupting you. So if somebody comes in, I see this sometimes, and the media puts a tape recorder or iPhone up on the dais, that's fine. If somebody sets up a camera in the back and starts recording, no problem. If somebody is sitting there live streaming on Facebook and providing commentary and being disruptive, that's out of order and you can ask that person to be quiet. They can sit there quietly as long as they aren't interrupting the meeting and record it. So just know that that is one of the rights protected of the public under the Open Meetings Act. Just a simple technical thing. If you have an open meeting and you close the door, make sure you put a sign on the door so that people know that they can come in. And similarly, if you've got an open meeting and you've closed the door for a closed session, I would make some sort of notice just indicating, the body is in closed session. What you don't want to have happen is somebody walk up to the board meeting, there's nobody there, maybe there's a window they can see in there, and they don't know whether or not they can come in. So 9 times out of 10, the door is open, people are just walking in. But if there's layers of security or whatever there may be to get to a board meeting, make sure that people understand that they're free to come in and they don't need to knock and they can just join the open meeting.
Matt, real quick, can you do that with an individual or staffer? For example, the board's sitting in there, they've been in open, but they've moved to closed. You've closed the doors. Uh, then you come back, and but there's no signage, but can you station a staffer there that says, "Oh, I'm sorry, they're in closed session right at the moment. As soon
Sure.
as as soon as they
Yep.
come back into open, we'll let everybody back in."
Yep. You can. Yep, I think door signs, if you've got the staffing to do that, having somebody make sure that it's clear, that's all good. I've even seen, a lot of public bodies are still broadcasting their meetings on electronically, even though members aren't participating electronically, hopefully, unless they meet one of those two criteria I talked about. I've seen where they close down the public part of the electronic meeting and say, the public body's in closed session. So just some amount of back and forth and communication, just so it's clear, I think is really important. Notices of meetings. One of my quick summaries at the beginning was no notice, no meeting. I think most people know that you have to post your regular meeting schedule at the beginning of the year. There's actually set deadlines to do that. You put them up at the building. If you've got a website, you do need to post it on the website. The thing that I see people get sideways with is changing meetings. So if you're going to change a regular meeting, the Open Meetings Act has a couple of requirements. If it happens at the previous meeting, so you're meeting 2 weeks before the meeting you're going to adjourn, you're supposed to make a motion. You're supposed to post it within a certain number of days, get it up on the website, and get it posted. That doesn't always happen. So if you have a meeting that gets, I see this just popped up in the chat. If you have to cancel something unexpectedly and you want to renotice it as a special/regular meeting. And just follow your board rules. The Open Meetings Act is sort of the minimum notice. A lot of board rules have more notice on a special meeting, but it's 18 hours and it has to be publicly available for the whole time. But that gets you out of this wonky middle ground if you're canceling and rescheduling a regular meeting between meetings. So that's just a practice tip. I think that something really easy for people to do. One note on special meetings, you do have to state the purpose when you're posting a special meeting. You don't have to do that for a regular meeting under the law, even though almost everybody does because they put an agenda up with their regular meeting. But on a special meeting, you actually have to say what it's for. But also note you're not confined to what you said it was for. Once you're in an open meeting, unless your board rules say otherwise, and they might, and you can always waive your board rules, but once you're in an open meeting, you can do whatever you need to get done. So that's just another thing that I think not everybody knows, but you can always add to agendas. I'm sure board rules have a process for doing that, even if it's a late item. There might be an override or a 2/3 or even a waiver of the board rules to get something done if there's an urgent need. The Open Meetings Act also has provisions for emergency meetings where if you don't have time to get a notice, you can fix it after the fact. So there's a lot of things that happen when you're doing meeting notices. And I just would encourage, especially members of the public body, to one, defer to your clerk, and two, if you're not sure, ask before the meeting starts to make sure that the meeting was properly posted. I sit on a couple of public bodies and I'm always reviewing the agenda and I look at the date and the time for the meeting. That's a common area for a typo to happen. And I'm not blaming anybody. It happens. You get a form going. You might have 2024 and 2025 mixed up for the first couple of meetings. That matters. And so if we identify that, I will still run the meeting if it's my meeting, but then I'll reenact the decisions at the next meeting just to avoid any issues on the notice.
Yep. Matt, circling back, and I'm glad you actually mentioned this because I, this morning, as a matter of fact, I fielded a question from a commissioner regarding a situation in his county where a township board has been apparently holding quite a few special meetings, and they will list a single action item or discussion item, but then once they begin the session, apparently they're conducting other businesses they're deeming fit. And just to hit again what you just said, as long as that's an open meeting and the notice has been provided and everything, they're fully within their authority to take that kind of action, correct?
There's no legal issue with doing that. Whether or not that has political consequences or causes strife with their board rules, that's a separate question. But to answer your primary question, Derek, there's no legal impediment to doing that under the Open Meetings Act. Free to proceed. Whether you should or shouldn't, different analysis.
And just quick time check. We have about 13 minutes left.
Yep. I'm going to dive into closed sessions. Only those reasons stated in the Open Meetings Act are permissible for a board to enter closed session. You have to state the specific statutory basis when you're making the motion to enter into closed session. I like to have a little descriptor and then just say the MCL number. So closed session to discuss strategy related to collective bargaining pursuant to MCL 15268-1C. That's a roll call vote. Some of these closed sessions require a 2/3 roll call vote. Some of them require a simple majority. Don't ask me why. I think that unless you have a problem getting to 2/3, assume that you need 2/3 on all of them, and then double check if you don't get to the 2/3, if it's one of the other 5 reasons. 4 of 9 require 2/3. 5 of them do not. And so if you have a situation where you can't get to the 2/3, take a look at the Open Meetings Act, make sure that you've got one of the ones to get in there properly, and then you can go ahead and proceed with the closed session.
We've got I'm sorry,
Sure.
we've got a quick question back on regular meeting schedules and canceling them. The question is, what if regular meetings are constantly canceled just for a special meeting to be held?
Well, there's no legal issue with that as long as you're posting your special meeting correctly. Functionally, I can understand that being frustrated when people are trying to have a schedule and keep to it. The whole point of the regularly scheduled meetings, and just know under the law, the board's only required to have a couple of meetings a year. Statutory meeting, equalization meeting, and organizational meeting. So however many meetings you have, whether it's a regular rhythm or not, you can always have more. And other than being frustrated by the fact that your schedule keeps changing, you don't need to worry much about how you've rescheduled a regular meeting if you're posting it as a special meeting. What you need to worry about is just making sure the posting meets the requirements of the notice period. And a lot of board rules, I just want to make this point, a lot of board rules have more in them about special meetings than the Open Meetings Act, like how to communicate it, whether it's sent via email. Some of them have a much longer notice period, like 36 hours instead of the 18. So it's really important to look at your board rules. Not that there's a legal violation there, but there could be a problem if somebody says, hey, we're not going to waive our board rules and you didn't give us enough notice.
And then another question here, a closed session. Do you need a motion to come out of closed session?
So this is great, and I've had this discussion with some commissioners before. I don't think you can be trapped in closed session. The AG's office has indicated that a decision or a motion to come out of closed session can be made in the closed session, and that seems a little counterintuitive because you're not supposed to make any decisions in closed session. Functionally speaking, I think the best practice is for who's ever chairing the closed session to say without objection, we're going to return to open session. And then when you get into open session, some sort of indicator that we've reconvened in open session. The next best thing, or maybe the best thing, is for the chair to say, okay, is everybody good? All right, we're going to go back into open session and we're going to make a motion to return to open session. That can also be done in closed session. So what I'm telling you is you've got the range of options, but I think that there's a really good reason practically to document the beginning and the end of a closed session in the minutes. And if you're making the motion to return to open session in the closed session, that's a separate set of minutes. And those closed session minutes are not to be disclosed absent a court order. So I think you should have something in the open meetings minutes when motion made to go into closed session, roll call vote, count the votes, and then somewhere in there, return to open session. And if it's a motion, indicate that there is a motion. But technically speaking, no, I don't think one is required, but I think practically speaking, it should be documented. Yeah, when in doubt, roll call it out. For sure, every single time you go into closed session, roll call, whether it's a 2/3 or a majority. Coming out of closed session does not require a roll call. but it's harmless if you do one. All right.
You have 8 minutes.
Okay. So just some things I want to make sure people are aware of. If you're going to go into closed session to discuss pending litigation, there's a case from 2018. You have to state the name of the case. So I argue that applies to administrative proceedings, anything with a case number. If you're going to go in and discuss specific pending litigation, the name of the case should be in the motion to enter closed session. We talked about ad nauseum the application for employment versus the interviews. I'm not going to hit that again. The catch-all for closed sessions is for material exempt for discussion or disclosure by state and federal statute. This one applies to a number of things, including certain exemptions under FOIA. So if you want to go in to talk about your county's cybersecurity practices, you can cite to the FOIA exemption and go into closed session. If you want to go in and discuss a written attorney-client privilege legal opinion, you go into closed session under this one. It's 268 paren 1 paren H. The Open Meetings Act, when it was last amended, they added this second subsection, which you don't need to worry about under MCL 15268. So most places and probably a lot of our guidance just has the letters. Please add the one in front of the various reasons to go into closed session. So you're getting 1H in there just to conform with what the statute now says.
All right. Couple of quick questions here. Number one, can a board disclose closed session minutes by majority decision of the board?
So the only way that closed session minutes get disclosed is via court order. If the board is trying to correct a non-conforming decision, you can't vote to release the closed session minutes. The way that you basically get the information out from the closed session is you make a motion in open session that covers the topic discussed in closed session. For instance, if you were in there discussing a settlement of a lawsuit, at some point you're going to settle the lawsuit, and the settlement agreement and the motion to do so is going to be part of the public record. But the closed session minutes need to be maintained separately. They need to be, they can be destroyed if they've been approved within a certain amount of time. I don't know many bodies that do approve them, but absent a warrant or a court order, you should not be disclosing what transpired in the closed session.
Okay. And second question, what if a board member asks for a roll call and are told no by the chair?
So it depends. To me, a roll call vote is a great way to document if there's going to be a split. Your minutes need to include the number of yays and nays on every action before the board. It doesn't necessarily require that there be a roll call unless you're otherwise legally required to do so, like the closed session, if you're going to extend the county's full faith and credit, if you're approving the county budget. Certain things do require a roll call vote. If you're going to do a millage, taxation requires a roll call vote. But otherwise, if you just want a roll call vote to show the names of how people voted, that is a procedural issue. It's a decision of the chair, but it can be overruled. The chair's not the king or the queen by the majority of the board. So in that situation, if one commissioner just asks for a roll call vote, it's not legally required, but wants one, chair says no, you can appeal the decision of the chair. And there may be an up or down vote, either for or against a roll call. I think that's a lot to go through to just simply say okay to a roll call vote, but that's the option if the chair isn't willing to give the roll call. All right. I'm going to jump ahead a little bit here because we are running out of time. I never know how much I'm going to talk, but Derek knows I can probably fill an hour without a lot of work. But enforcement. So Open Meetings Act enforcement kind of goes through cycles. I've been seeing a bit more of it, especially with this committee and subcommittee delegation issue. But just know that if you're in a closed session and the sheriff or a state police person comes and asks you what was discussed in the closed session, you could potentially violate the Open Meetings Act by disclosing it absent a warrant or court order. So your notes are not FOIAble unless they were used to prepare the minutes of the closed session, and even that wouldn't be subject to disclosure unless there was a court order ordering it. But you are really not to talk about the nuts and bolts of a closed session uh, outside of it. And if somebody's was in there, also a commissioner, not a big deal. But if somebody comes and is investigating an Open Meetings Act violation and wants you to voluntarily disclose what happened in the closed session, I would talk to professional staff. If I'm a county commissioner, I'm calling the controller or the administrator. And then if I'm the controller and the administrator, I'm probably calling the county attorney. And voluntarily sitting for an interview with a law enforcement person asking about closed session should be a very deliberate and planned out process. And they might have a warrant, and that's fine. And you might have a court order, but unless or until you have those things, do not get yourself sideways of the Open Meetings Act by trying to voluntarily cooperate with an investigation. Even if you think that something wrong happened, there's steps that need to happen first so that you don't get charged with a misdemeanor for intentionally violating the Open Meetings Act by disclosing voluntarily what happened in the closed session. So be careful with that. There's civil actions. Open Meetings Act allows for civil remedy. People can get attorney's fees if they prevail. Typically, what I see in that case, if we identify an issue, if you've been sued, we just tell you to reenact it. Like I said earlier, there's no prejudice against you in court for fixing it after the fact. If you didn't violate it, you might want to fight it. But if you did violate it, let's just fix it and move on. All right, 12:59, Derek.
Yep. Any final words, Matt, before I touch on some notes for everybody?
No, just please flag for yourselves and your colleagues this issue about delegation. I don't want there to be an overreaction. Obviously, county administrators, controllers, they do a lot, and they're supposed to do a lot as it relates to preparing things and implementing stuff for the Board of Commissioners. Every time you tell your administrator to do something or bring something back, you're not necessarily delegating your role. You're just directing them in the performance of their duties. But if you took something from a committee and were pretty clear that you're delegating it to somebody else, take a look at that one. And you may not be able to accomplish what you hope for, which is a more confidential review. You still could figure it out, even if you do create a public body through a delegation. That public body may post and nobody might care or show up, or maybe you can go into closed session. But just that delegation thing, that's a flashing red light right now on committees, subcommittees, whatever you call them, task force. Just be careful with that.
Great. Wonderful. Thanks everybody for staying with us the whole hour. Just very quickly, we will be sending out Matt's slides after the event. Give me a couple of days on that. In addition to those slides, I'll also attach the article we had in the Michigan Counties Magazine back in February that goes into this delegation issue to much greater degree. Always great to have it around as a reference point. We have recorded the session. I still have to figure out exactly how I'm going to share that recording. So bear with me as I get all of that developed. I'll be in touch by email with all the attendees today who have earned their 1 credit through County Commissioner Academy. This is exactly what we're wanting to do with CCA, and we appreciate Matt and his firm for allowing us to help our commissioners in this way. So have a good rest of your day, everyone, and to you, Matt.
Thanks, everybody. Bye-bye.